Just when the public thought Mackenzie Shirilla's legal options were completely dead, her defense team launched a high-stakes emergency maneuver. On July 7, 2026, her lawyers officially filed a motion for reconsideration with the Ohio Supreme Court, desperately fighting the rejection caused by a one-day filing error. Her team argues that a leap year calculation mistake shouldn't permanently strip a lifer of her constitutional right to an appeal. Can a single emergency petition force the state's highest court to completely reopen a double murder case? Today, we go inside the unsealed filing to dissect this final, dramatic, legal lifeline. To stay updated on the most critical justice system battles, please make sure to subscribe to U.S. Crime Cases and hit the notification bell today. Before we dig into the incredibly complex web of state Supreme Court dockets and statutory deadlines, I need us to take a moment and step back. We really have to remember why we're even having this conversation in the first place. Because at the absolute center of this massive legal battle are two young men who had their entire lives ahead of them. Dominic Russo, who was just 20 years old, and Davion Flanagan, who was only 19. On the early morning of July 31st, 2022, their lives were abruptly and violently cut short in the Cleveland suburb of Strongsville, Ohio. It is incredibly heavy when you really think about the families they left behind. I look at the endless court dates, the multiple appeals, the relentless media attention, and you just know that for the Russo and Flanagan families, the grief does not pause. It never simply turns off. Every single time a new legal motion is filed, they are forced to relive that horrific summer night all over again. They have been waiting, hoping for permanent closure, and trusting the justice system to give them some semblance of peace. The entire community of Strongsville was shattered by this event. It was not just a passing headline. It was a devastating local tragedy that left friends and loved ones trying to piece together how a late-night drive turned into an absolute nightmare. We must always keep Dominic and Davion in our minds as we navigate the highly technical sides of this ongoing case. If you remember the original details of the crash, Mackenzie Shirilla was 17 years old at the time. She was behind the wheel of a Toyota Camry, with Dominic and Davion riding as passengers. Police investigators and crash reconstruction experts stated the vehicle accelerated to roughly 100 miles per hour before slamming directly into a commercial brick building in an industrial park. The data pulled from the car's black box was chilling. Prosecutors argued during the trial that it showed she pressed the accelerator to 100% throttle. They said she intentionally steered into the wall and never once hit the brakes. The impact was so severe that both young men were pronounced dead at the scene. Mackenzie survived the crash with severe injuries, and her defense team has always maintained that she has absolutely no memory of the collision. From the very beginning, they argued that the crash was entirely unintentional. Mackenzie chose to have a bench trial rather than a jury trial, meaning a single judge would determine her guilt or innocence. When her case went to trial in 2023, her attorneys briefly referenced a pre-existing medical condition, suggesting she might have suffered a severe medical episode and blacked out behind the wheel. But the presiding judge, Judge Nancy Margaret Russo, did not find that argument compelling based on the evidence presented by the state. The judge stated that Mackenzie's actions were premeditated, going so far as to call her hell on wheels during the courtroom proceedings. The judge found Mackenzie guilty of 4 counts of murder, along with felonious assault and aggravated vehicular homicide charges. She was sentenced to 2 concurrent life sentences with the possibility of parole after 15 years. Official records show her first parole hearing is not scheduled until 2037. For a lot of people watching, that verdict felt like the final chapter. You see the gavel come down, the sentence handed out, the prison transfer finalized to the Ohio Reformatory for Women, and you logically assume the story is over. But the American justice system rarely moves in a straight line, and behind the scenes, the legal machinery keeps churning. Fast forward to today, and we are looking at an official, highly contested docket entry from the Ohio Supreme Court. It is an incredibly active, real-time conflict playing out right now in July of 2026. To understand exactly what her new defense team is attempting to pull off, we have to look closely at a specific legal avenue known as post-conviction relief. In the Ohio justice system, a direct appeal only lets you argue about the things that happened exactly on the record during your original trial. But a post-conviction relief petition is a completely different tool. It is a critical, separate legal lifeline that allows a convicted person to raise constitutional claims or introduce new evidence that was never part of the original trial record. This was the exact path Mackenzie's new lawyers wanted to take. They wanted to officially introduce proposed new medical evidence that they claimed would support the theory that she blacked out before the crash. However, the state legislature places rigid, unforgiving boundaries on when you can actually file this paperwork. Defendants are granted a highly specific window to submit this petition. Under Ohio law, they have exactly 365 days after their original trial transcripts are filed in the Court of Appeals to get that document on the docket. This brings us to the monumental procedural obstacle blocking her case. Mackenzie's previous legal team entirely blew past this strict statutory deadline. Because they missed the cutoff, the lower courts ruled that they completely lacked the legal authority to even look at the proposed medical evidence. The trial court essentially said the paperwork was late, making them statutorily barred from opening the file. The 8th District Court of Appeals later unanimously backed up that dismissal, stating that the missed deadline left the trial court without any legal jurisdiction to consider the merits of the blackout argument. The calculation error her previous lawyers made is almost hard to believe, but it happened, and it all revolves around the calendar. During her direct appeal, the clerk of courts officially docketed her criminal trial transcripts as being filed on October 24, 2023. If you are a busy attorney, you might casually look at that date, add a year to it in your head, and assume you have until October 24th of the following year to file your post-conviction paperwork. Her prior counsel operated under this exact assumption, filing the critical petition on October 24, 2024. But they forgot one vital, catastrophic detail. The year 2024 was a leap year. Because February had 29 days, the statutory count of exactly 365 days did not miraculously land on the one-year anniversary date. Instead, it shifted. The final day to file legally landed exactly 1 day earlier on October 23rd, 2024. Because the paperwork was time-stamped on October 24th, it arrived on day 366. Adding to the confusion, her new legal team argued that the deadlines themselves were inherently misleading. They pointed out that secondary juvenile bindover transcripts were filed weeks after the main trial record, meaning the clock should have theoretically started later. But the courts firmly rejected that argument, stating the criminal trial transcript date is what triggers the countdown. That 1 day delay resulted in the Ohio Supreme Court issuing a brief entry on June 23, 2026, officially declining to accept jurisdiction of her appeal. It was a 6-1 decision, with 6 justices agreeing to shut the door. But Justice Patrick DeWine served as the lone dissenting voice against the dismissal. When a Supreme Court rules 6-1, it usually signals that the legal questions are overwhelmingly settled. But that single dissenting vote from Justice DeWine is exactly what the defense is desperately clinging to right now. That brings us to the emergency maneuver filed on July 7, 2026. Her lawyers submitted a motion for reconsideration under Ohio Supreme Court Practice Rule 18.02. This is not a brand new appeal, nor is it a chance to dump new evidence on the justices' desks. It is a highly specialized, incredibly narrow request, asking the 7 sitting justices to look in the mirror, review a decision they just made weeks ago, and admit they made a mistake. Reversing a jurisdictional decision is an exceptional and highly uncommon maneuver. The justices will review the filings behind closed doors without hearing public oral arguments, hold a vote, and issue a written order. Her team is aggressively arguing that a basic mathematical leap year mistake by an attorney should not permanently strip a convicted teenager of her Sixth Amendment right to effective counsel. The Sixth Amendment guarantees every defendant the right to competent legal representation. Mackenzie's current lawyers argue that missing a statutory deadline by exactly 24 hours is the very definition of ineffective counsel. They argue that this strict adherence to a calendar technicality constitutes a massive miscarriage of justice. They claim that an inmate should not face a lifetime of imprisonment without review, simply because their chosen representation could not accurately calculate a leap year. On the flip side, prosecutors and the state maintain that deadlines are absolute. They firmly believe that if the Supreme Court starts ignoring statutory rules simply because a lawyer could not properly count days on a calendar, it sets a dangerous legal precedent. The state's position is that the families of the victims should not have their healing endlessly delayed by out-of-bounds legal maneuvering. The rules exist to protect the integrity of the system and to provide finality. Ohio law strictly dictates that if a post-conviction petition is late, a court can only excuse the delay under incredibly narrow exceptions, such as discovering post-conviction DNA testing that proves actual innocence. Since a calendar mistake does not fit those exceptions, the state argues the courts have zero legal jurisdiction to bend the rules. If the courts make an exception for a one-day delay today, they argue it completely undermines the foundation of the appellate process. This leaves us with a profound debate sitting on the desks of the highest court in Ohio. Should a clerical oversight regarding a calendar date override a person's constitutional right to have a life sentence evaluated, or must the justice system rigidly enforce its boundaries to protect the families who have already lost everything? We will be watching as the state files its opposition, waiting to see if this emergency petition can actually force the court to reopen a closed door. But the justice system rarely moves in a straight line. Behind the scenes, the legal machinery just keeps churning, often completely indifferent to the human toll it takes. When the original trial ended, so many people in the community thought the families of Dominic Russo and Davion Flanagan finally had their peace. You watch the evening news, you see the heavy sentencing handed down, and you naturally assume the book is closed forever. But in reality, the physical trial is often just the beginning of a very long, very painful appellate journey. For the parents and loved ones of those two young men, this means the nightmare does not simply switch off. Every single legal maneuver, every emergency motion filed in Columbus pulls these grieving families right back to July 2022. The state appellate process drags them back into the courtroom emotionally, even if they are sitting quietly in their own living rooms. It is just incredibly heavy when you sit down and really think about it. Fast forward to today, and we are looking at an official docket entry directly from the Ohio Supreme Court. It is stamped July 7, 2026. This proves that we are looking at an incredibly active, real-time conflict. The filing was made under case number 2026-0519, officially titled State of Ohio vs. Mackenzie Shirilla. If you have never looked at a Supreme Court docket before, it is basically a massive public ledger that tracks every single piece of paper moving between the defense attorneys, the state prosecutors, and the judges. And right now, that specific ledger is lighting up with emergency activity. To understand exactly what her new defense team is attempting to pull off with this document, we really have to break down the specific legal tool they are using. Under Ohio Supreme Court Practice Rule 18.02, they filed what is formally known as a motion for reconsideration. Now, I want to be entirely clear here because I see people get confused by this all the time. This is not a brand new appeal. It is not a chance for the lawyers to just walk into the Supreme Court and dump a fresh box of new evidence on the justices' desks. Instead, it is a highly specialized, incredibly narrow request. They are essentially asking the 7 sitting justices of the state's highest court to look in the mirror, thoroughly review a decision they just made a few weeks ago, and openly admit they made a mistake. They are literally asking them to reverse their own ruling. Wow. It is a bold and statistically rare maneuver. Getting any Supreme Court to admit an oversight and walk back a dismissal is a massive uphill climb. In this specific scenario, Mackenzie's defense team is fighting against a ruling that was handed down on June 23, 2026. On that Tuesday, the Ohio Supreme Court issued a very brief, incredibly sharp entry. They stated clearly that they were declining to accept jurisdiction of her appeal pursuant to Rule 7.08b(4). Basically, the court said, "We are not taking your case and we are not going to hear your arguments." The vote held behind closed doors was a 6-1 decision. 6 justices fully agreed to shut the door and leave the lower court's dismissal entirely in place. Right? That is a heavy, almost overwhelming defeat for any defense team. But Justice Patrick DeWine served as the lone dissenting voice against that dismissal. When a Supreme Court rules 6-1, it usually signals that the legal questions are completely settled in the eyes of the bench. The law is the law. But that one single dissenting vote from Justice DeWine is exactly what the defense is clinging to today. They are hoping his isolated viewpoint can somehow persuade his colleagues to take a second look at the paperwork. He saw something in the filings that made him believe the highest court should at least let the defense make their argument. It is a monumental uphill battle for her new lawyers, but in the legal world, until the state docket is permanently sealed, attorneys are going to fight for every inch. If you haven't subscribed to U.S. crime cases yet, hit that button right now to stay updated on this active case and join our community. So what exactly is blocking her case from moving forward? Why did 6 justices turn her away? It all comes down to a single missed deadline regarding her petition for post-conviction relief. If you are not familiar with this specific legal term, I can explain it simply. In the Ohio justice system, a direct appeal only lets you argue about the things that happened exactly on the record during your trial. The appellate judges just read the original transcripts, look at the admitted evidence, and search for legal errors made by the trial judge. You absolutely cannot bring in surprise witnesses, and you cannot hand over new documents that the trial judge never saw. But a post-conviction relief petition is a totally different legal tool. It is a critical avenue that allows a convicted person to raise constitutional claims or introduce entirely new evidence that was not part of the original trial record. This is the safety net built into the system for situations where critical evidence was somehow missed, suppressed, or newly discovered. This was the exact avenue Mackenzie's new lawyers wanted to take. They desperately needed to look outside the original trial record to build their case. To fully grasp why they needed this tool, we have to look at what happened during the bench trial. Police and crash reconstruction experts testified that the data pulled directly from the Toyota Camry's event data recorder, the black box, showed the car accelerated to roughly 100 miles per hour. Prosecutors told the court the data proved she pressed the accelerator to 100% throttle, steered directly into the commercial building, and never once applied the brakes. The trial judge found that technical evidence incredibly damning, which led directly to the murder convictions. Because the original trial record contained that devastating mechanical data, Mackenzie's new appellate team wanted to introduce proposed new medical evidence. They claimed this outside medical documentation could support a theory that she actually suffered a severe medical episode and completely blacked out behind the wheel before the crash. They want to argue that a sudden blackout explains the lack of braking and the intense acceleration. They believe this evidence proves the crash was a horrific unintentional tragedy rather than a purposeful act. But there is a massive catch to introducing new evidence. The state legislature places rigid, unforgiving boundaries on when you can actually file this specific paperwork. You cannot just come back to the courts 3 or 4 years later whenever you feel like your case is ready. Under Ohio Revised Code 2953.21, defendants are granted a highly specific ticking window to submit this petition. They have exactly 365 days after their original trial transcripts are filed in the Court of Appeals. Not a calendar year, not roughly 12 months, exactly 365 days. This incredibly strict deadline is not just arbitrary red tape designed to frustrate lawyers. The state strongly argues that these deadlines exist to provide permanent finality. The rules are in place to ensure that cases eventually come to a definitive end. Prosecutors maintain that court deadlines protect the families of victims from being endlessly dragged through the legal system year after year. When the Ohio legislature wrote 365 days into the law, they did so to create a firm, undeniable line in the sand. If the justice system allows lawyers to casually ignore that line, prosecutors argue it completely destabilizes the integrity of the courts. The expectation is that if you want the highest court in the state to review your murder conviction, you must respect the basic rules of procedure. And that rigid boundary is exactly where Mackenzie's previous legal team stumbled, setting off this massive, high-stakes battle over a calendar. Think about the immense pressure riding on this single July filing. Mackenzie is currently serving an aggregate sentence of 15 years to life at the Ohio Reformatory for Women. Official records state her first parole hearing is not scheduled until 2037. If this motion for reconsideration fails, if those 7 justices refuse to reverse their decision, this specific legal door closes forever. The proposed medical evidence about the blackout theory will likely never be evaluated by a trial court. That is exactly why her new attorneys are fighting with such incredible intensity. They are watching a permanent lock being placed on her case, and they are using Rule 18.02 as a final desperate key to try and jam it open. You see the intense collision between human lives and cold, hard statutory law playing out in real time. The state wants closure for Dominic and Davion. The defense wants a chance to explain the crash. And standing right in the middle is a ticking clock of 365 days. This brings us directly to the immediate procedural obstacle blocking her path. And honestly, it is a stunning mistake when you read Mackenzie's previous legal team entirely blew past this strict statutory deadline. Because they missed the cutoff, they completely lacked the legal authority to even look at the proposed medical evidence. The court essentially said, your paperwork is late, and because it is late, we are statutorily barred from even opening this file to see what you have to say. The new defense team is now attempting a massive legal rescue mission to get the state's highest court to overlook this procedural blunder. But how did her previous lawyers miss something so incredibly important? When a life sentence is on the line, you would assume every single date is double and triple checked. The calculation error they made is almost hard to believe, but in the busy reality of law offices, it happens. During her direct appeal, the clerk of courts officially docketed her criminal trial transcripts as being filed on October 24th, 2023. If you are an attorney, or really just anyone looking at a calendar, you might look at that date, add a year to it in your head, and assume you have until October 24th of the following year to file your post-conviction paperwork. Her prior counsel operated under this exact casual assumption. They prepared the documents and filed the critical petition on October 24th, 2024. But they forgot one vital detail. The year 2024 was a leap year. Wow. It is such a small thing on a calendar, but it has monumental legal consequences. Because February had 29 days, the statutory count of exactly 365 days did not miraculously land on the 1-year anniversary date. It actually shifted. The final day to file legally landed exactly 1 day earlier, on October 23rd, 2024. Because the paperwork was officially time-stamped by the clerk on October 24th, it arrived on day 366, right? Just 24 hours late. But in the eyes of the law, it might as well have been a decade late. Judge Nancy Margaret Russo, the same judge who presided over the original bench trial and handed down the life sentence, ruled that the petition was invalid as a matter of law. When a judge makes a ruling like that, it is not necessarily about them being vindictive or refusing to listen. The court said it is an issue of subject matter jurisdiction. Simply put, once a statutory deadline passes, a judge physically loses the legal power to hear the case. They cannot just bend the rules because they feel bad about a calendar mix-up. The 8th District Court of Appeals unanimously backed up that trial court decision. The appellate judges stated clearly that they had absolutely no jurisdiction to consider the merits of the blackout argument because the filing arrived a day late. I see people online asking why the courts are being so rigid about a single day. The appellate court actually addressed this directly. They pointed out that while Ohio law uses the term 1 year in certain civil statutes, which allows for anniversary dates regardless of leap years, the state legislature specifically chose the exact phrase 365 days for post-conviction relief timelines. They argued that lawmakers used that specific number to completely remove any ambiguity. 365 days means exactly that, no matter what the calendar year looks like. This creates the ultimate high-stakes question at the absolute core of this new July 7th filing. Her new legal team argues that a basic mathematical leap year mistake by an attorney should not permanently strip a convicted teenager of her Sixth Amendment right to effective counsel, nor her right to an appeal. The Sixth Amendment is a foundational part of the justice system. It guarantees that if you are facing criminal charges, you have the right to a competent lawyer who will fiercely advocate for you. Mackenzie's current lawyers are arguing that failing to properly calculate a basic statutory deadline is the very definition of ineffective assistance. They argue it is a horrific miscarriage of justice to punish the client for the administrative failures of the lawyer. They are essentially telling the Ohio Supreme Court that an inmate should not be locked in a cell for 15 years to life without a proper review of medical evidence just because someone forgot February had an extra day. They want the justices to recognize that human error in a law office should not override a constitutional right. On the flip side, the prosecution and the courts have maintained that deadlines are deadlines. Prosecutors firmly believe that if the Supreme Court starts ignoring the Ohio Revised Code simply because a lawyer could not properly count down days on a calendar, it sets an incredibly dangerous precedent. If you bend the rules for a 1-day delay today, what happens tomorrow? Do you excuse a 2-day delay, a week, a month? The state argues that you cannot run a functioning justice system if the boundaries are constantly shifting based on who made a mistake. But the state's argument goes much deeper than just protecting court procedure. It goes right back to the human element of this tragedy. The prosecution's position is that the families of Dominic Russo and Davion Flanagan should not have their healing delayed by endless out-of-bounds legal maneuvering. The rules exist to protect the integrity of the system and to provide finality for the victims. We really have to empathize with what these families go through every time a new motion hits the docket. Every time an appeal is filed, the state prosecutors have to notify the victims' families. They get a phone call telling them the person responsible for the deaths of their sons is once again trying to get the case reopened. That completely shatters whatever fragile peace they might have built since the last court date. The state argues that enforcing the 365-day rule is how the justice system protects these families from eternal litigation. The state essentially says, the deadline was missed, the window is closed, let these grieving parents finally rest. So this is exactly where we stand today. The Ohio Supreme Court justices are looking at a profound, deeply complicated dilemma. On one hand, you have a defense team pleading for a constitutional lifeline, arguing that a leap year miscalculation is an extraordinary circumstance that warrants a second look. They want the court to focus on the proposed medical evidence and the young woman sitting in prison. On the other hand, you have the state demanding strict adherence to the law, protecting the finality of the convictions, and prioritizing the closure of the victims' families. The 7 justices will review the filings behind closed doors. There will be no cameras, no public testimonies, and no dramatic courtroom speeches for this specific motion. They will simply read the arguments, debate the merits of the leap year mistake, hold a private vote, and issue a written order. Should a clerical oversight regarding a calendar date override a person's constitutional right to have a 15 years to life murder conviction evaluated by the state's highest judicial body? Or must the justice system rigidly enforce its boundaries to maintain order and protect the families who have already lost everything? That is the heavy, monumental question sitting on the desks in Columbus right now. We are all just waiting to see how they answer it. Thank you so much for staying till the very end. If you haven't yet, please subscribe to U.S. Crime Cases for more important legal updates.